it gets more interesting. So you have freezers, coolers. So this is obviously refrigerating equipment, which back in the day used to be a heavy user of the CFCs. But let's look at this one: electronic typewriters and word processors. Then you have, those are not there are mechanical ones, right? But electronic typewriter and word processor under this one, this would not be the computer. Computer would be in a different category. But take a look at this one: electronic calculators. So the stuff that you use to calculate can be subject to ozone depleting tax, right? And that's an excise tax which you may have to pay upon the entry. You have accounting machines, cash registers. You have digital automated data processing machines. Now, automated data processing machine is another word for the computer. So you bring in a computer, let's say you're the Best Buy, right? And you do a lot of sales and you acting as the importer of record, the liability may arise. So here we have laptops, notebooks, digital processing units, keyboards, display units, printer units, pretty much all the products of the electronic spectrum. Modems, faxes, phones, radios, speakers, avionics. So all this stuff is covered under IRS excise tax law for ozone depleting chemicals, right? So why? And here is again, notice they codify the taxable event, the notion of taxable event, and then they give you examples of how you calculate the tax. If you read through this, if you read this carefully, you may understand that with the progression and the industry itself has pretty much made a move to depart from ozone depleting chemicals by and large. But it's still their responsibility, and this has to do with presumptions, and this has to do with compliance, where you have to calculate where amount of ozone depleting chemical, or at least you have to take steps to figure out if this stuff applies to you, right? So number one, the way you calculate is through exact method, right? And what you do is you go to the manufacturer and you ask him, are you using any ODCs, any ozone depleting chemicals? And if he says no, and he gives you what's otherwise called sufficient and reliable information, right? This can be good enough. But it must be done, right? And this is part of the due diligence process. And if the manufacturer is not able to provide you, you go to the default method where you do this on the basis of this table. So let's say you bring in a calculator, right? Or the camcorder, right? And your manufacturer is not able to provide you whether or not he's using CFCs, basically non-responsive, right? So is this a presumption or not? That's the question of whether you have a tax liability as an importer of record, because you use or sell the product in the United States, and you use this as a part of the formula in calculating whether the liability arises and how much you need to pay. I'm not going to go into the calculation, right? I just want to mention this real briefly to connect it to the real world and the real world of how things like that become more and more important in our day-to-day jobs as a licensed customs broker, as a compliance manager, as a transportation manager, as a quality assurance manager, right? So in this year, in 2016, it became even more important. And here is the reason why. So let me pull up an interesting case. which was brought by customs fraud investigations against a company which imports pipes, tubes, pipe fittings, etc., etc. The company is called Victalic, and customs fraud is a plaintiff. All right. So we're looking for the recent case because that one came down really hard and was made the news among the international trade community. So what's going on with this case? Why is this case so important and matters to the taxes, to the declaration, to the compliance of the stuff we are talking about right now? First of all, what this case stands for is a proposition that what is called as False Claim Act. So we're talking about False Claim Act, which is also known as Lincoln Law, is very much alive and well in the field of customs. What happens in this case? In this case, you have a company which is called Victalic, which is one of the major importers of the pipe and pipe fittings and related products. It didn't what these guys have investigated and uncovered is that those guys, whenever they bring in something into the country, their product is non-compliant. And it's not compliant with the customs regulation dealing with marking. And if you do not mark your product correctly, there is a provision under the customs law which imposes 10 duty ad valorem, 10% tax on the product cost. And what the reason they got involved is customs apparently wasn't finding the laws, wasn't enforcing the laws against those guys, and those guys were getting a free ride. And what Lincoln Law does, or the False Claim Act, it allows those guys, on behalf of the government, also known as realtors, to sue companies like this, which they allege to be non-compliant, and get a piece of the pie, because they did all the work. They are entitled to some of the cut, right? And going back to the history, that law dates back to the Lincoln era. That's why it's called Lincoln Law, because during the time of Civil War, there was a lot of abuse in charging suppliers, overcharging the federal government, the union troops, the union government, in provision of food, in provision of clothing, in provision of weapons, etc., etc., etc. And to fight this abuse, that law was passed so the private parties had an incentive to report on the abuses where the federal government is being harmed, right? So until this case came out, and we're talking about the Third Circuit. So this is not a decision of the district court, which is lower. It's a decision of the appellate court, right? So what we have is in the federal system, we have district courts, so equivalent to be Court of International Trade. Then we have circuit courts, and then we have Supreme Court. So usually this is a pecking order. And in this case, we're talking about the appellate, the Court of Appeals, right? And they held that these guys actually have a case. And what they've done, the Customs Fraud Investigation has done, is they bought some pipes of eBay, and then they did some data statistical analysis, and they said, based on our statistical distribution method, and they provided experts, etc., we believe that these guys are not marking their products which they're importing for a number of years, and therefore they're subject to the 10% duty. So before this case came out, those type of cases would have come up in the area of anti-dumping, and those type of cases usually dealt with anti-dumping duties evasion, and the courts in that area circumscribe this application of False Claims Act, because you pretty much, to succeed, you pretty much had to have insider information, insider knowledge. Now, with this case, it said, well, insider knowledge is helpful, but it's not required. Let me do some quotations just to show you how powerful this case is, and later on we'll apply it to the taxes, since our conversation is excise taxes, and what kind of role it can play. So okay, so here's one quote. False Claims Act specifies that mere knowledge and avoidance of an obligation is sufficient without the submission of false record to give rise to liability under False Claims Act. Notice that mere knowledge and avoidance, and knowledge can be it also can be something which knowledge and deemed knowledge. So you are deemed to know, to have this, because you are responsible for this product, and this is something which is not to be avoided by just closing your eyes or ducking your head into the sand. Here is another interesting quote. So the plaintiff, the customs fraud investigation that sues under the False Claims Act, need only prove that Victalic knew its pipe fittings were improperly marked and did not notify customs, since to do so is to conceal information from customs officials that customs officials needed to know in order to determine whether to release Victalic goods from its custody. Right? And to kind of finish it up, the statutory text, legislative history, and policy rationale underline the regulatory regime all lead to one conclusion: reverse False Claims Act liability. Reverse is where you underpay the duties, you avoid duties, may attach as a result of avoiding, in this case it was marking duties. So going back to our camcorders, going back to our modems and electronic devices, the repercussions, especially for folks in compliance field, especially for people who are working in the import departments and trying to make sure that the product fulfills the regulation. As a result of this case, you may have individuals and companies going to places like department stores and looking up this information and checking whether again, this may be hard to check because some insider information may be required, but this is what disgruntled employees, which there are many nowadays, right? Because the economy is hard, many people get fired, laid off, reduction of workforce, etc., etc. But keeping that in mind, it may be easier for, especially now when we live in an information age, to see whether you're compliant or not. And if you are not paying taxes, and you should have known that you're paying taxes, that liability under this new standard by the Third Circuit for the False Claim Act may give rise to potential liability, not only from the government side, not only from the government standpoint, but also from the private individual company standpoint, who is looking to get a piece of piece of the pie in penalties, right? All right, so that's why this case is so important. Now let's go back to to our outline and see how it plays, how examiners have tested on this stuff before. So pretty much what happens is, notice you have CATER, right? Customs and automated trade, automatic interface requirements. One of the things that customs have been required examinees to bring to the table is this appendix, right? And in this appendix you find tables. So, for example, let's pull up customs appendix, CATER appendix B. It is freely provided, made available on the website. So, in this situation, we have I provide links on the lawcustoms.com website, and it is under the customs broker, customs broker exam provision. So the relevant table for the alcohol, distilled spirits, and as well as for tobacco products would be in page 20 and page 21 of the appendix. So let's see. Okay, so we have appendix B valid code, and then we're going down and we're taking a look at going to the page B20. Please, when you show up to the exam, mark these pages, as these are very important pages. So here is a page for B20, right? And it deals with a table for tax fee codes for beer, wine, alcohol, and perfume. And B21, which deals with tobacco products. And with those tables help, you will be, it will enable you to answer questions related to the excise tax, which is applicable upon importation. So, going back to our outline, we have a customs examiners asking the following question. And this was pretty recent. I believe this was within like the last year. So let's see what customs examiners say. So what is the amount of IRS excise tax on 72,000 small cigarettes with the following characteristics? So you immediately know, once you see the excise tax, you immediately know that you are in the area of CATER Appendix B, right? So what are the relevant facts? Well, first of all, you have to look at the product, right? This is helpful, but notice those tables, they are not necessarily giving you all the information you need. So since the question deals with tobacco products, we are dealing with the CATER Appendix D table dealing with tobacco, right? And what customs has done in that question is they try to make sure it fits the description. Notice there is no HTS code here, right? It may be helpful in a different way, which we shall see in a bit. There is some provision for HTS code over here, but again, usually go off the description. So going back to the question, what we see is we see the buzzword is small cigarettes, right? Small cigarettes, right? Then we have characteristics where they do not exceed 3 pounds. So it's less or equal than 3 pounds per 1,000. And we have an entered value, we have weight, and etc. etc. Let's go to the table and take a look at the characteristics. So first of all, we know we're dealing with small cigarettes. Going down the list, and the list is not that big, so that's fortunate for the examinee. We have small cigars, large cigars, small cigarettes, large cigarettes, chewing tobacco, pipe tobacco, cigarette paper, cigarette tubes. So here we have small cigarettes not exceeding 3 pounds. So we have 3 pounds per K, right? So I know we're here K. We are in a world of abbreviations. For I know that a lot of folks who take this exam, they may not be native speakers. So the pinning down what abbreviation like K, which is usually associated with 1,000, may not be something which is so simple that it's on the face understandable. So in this case, what I would suggest is to pull up what's the publication called by customs. Again, this is not something required, but this is something which is highly suggested to bring. Appendix C. Appendix C, tariff abbreviations, CBP and trade. So it's also part of CATER, although now it applies to, I believe, ACE, not automated commercial environment, not automated commercial system, or also known as ACS. And that table pretty much lists all the abbreviations which are necessary and can come up on the exam. So here's the list, right? So let me make it a little bit bigger. Okay. So as we look forward, see that K over here, it means 1,000, right? So those are the abbreviations which are commonly used throughout the tariff schedule and Code of Federal Regulations. So this is something which can be helpful. For the relevant ones, I put it in a little table of outline, the things that matter, right? So you can use this one as well. It is part of outline, part of the book, part of the material. So let's go back to our question. So our task is, so we pretend like you are a licensed customer broker, and you need to figure out how much tax you need to declare for your client for 72,000 small cigarettes. And we're talking about stuff that you usually buy in a corner store, like Marlboro, Winston's, those stuff, right? And so where do you start? So we pin down the appropriate line item on the table. Next. We need to figure out the rate which is charged. So we know that this one, small cigarettes not exceeding 3 pounds per K, applies. Here we have two boxes which are very much relevant. This one states that per 1,000 cigarettes you pay $50.33 in excise tax. So it would be $50.33 per 1,000. Okay. So this is the starting point. Next, you go to the amount and you see 72,000. So 72,000. You can just take out the zeros here, and you can multiply $50.33 by 72, and what you'll get is this answer: $33,623.76. Notice, customs provide you with a lot of other information which may not necessarily be relevant, right? But customs may not necessarily provide you with only relevant information. So your job is to figure out the relevant facts. Here is another interesting point. Again, on a side note, since CBP examiners provided us with the HTS code for the cigarettes, it will be kind of curious to see what it looks like. So if we go to, it's provided for under HTS 2402 28,000, right? So let's look it up. Let's pull up the HTS table and see how it looks like. Okay. 2402 28,000. Okay. Right there. Okay. So yes, you have cigarettes containing tobacco, paper wrapped, and this is the amount of duty you pay. So you pay 1.05 per kilogram plus 2.3%, and then you pay excise tax. I think this means that there is a footnote, is the one that we deal with the excise tax. And in fact, it is. So if you look at that footnote, it says imports under this provision may be, probably must be, subject to federal excise tax, and they even provided the USC code. And of course, remember going back to the earlier lecture when I provided the packing order for the USC code, is you have USC, which is made by Congress, and pursuant to which Code of Federal Regulation is made, CFR, and CFR merely fills in the blank, but United States Code is more general. Sometimes it is not so general, and I think this is one of the good examples. So let me pull up that. So see, we have a provision here, 2826, and 26 is the title. Remember, going back to our ozone depleting chemical tax, when we talk about 26, what we saw was the title for the IRS code. This title is also mirrored in the United States Code because this is just makes it easier reference. It doesn't always have to be mirror image, but usually it is. So we're dealing with 5701. All right. So my favorite lookup tool for the United States Code is right here. It's again on worldcustoms.com website. Here, United States Code. It is published by the House, so we'll go with 26, and we'll go with 5701. All right, so check it out. Rate, taxable rate, and here's what Congress stated. On cigarettes manufactured or imported into the United States, there shall be imposed the following taxes. Small cigarettes weighing not more than 3 pounds per thousand, which is what we dealt with just now in that example, $50.33 per thousand. So, because customs cannot ask you on a question issue which deals with USC, because usually they do not require United States Code, they only require Code of Federal Regulation, this is something extra. But I think to have a general, bigger picture in mind also helpful where the stuff comes from. Also notice what the Congress has said in the law, that it doesn't, remember in ODC we had this notion of taxable event, sale or use, and this option to declare. Here Congress exactly said, if it's imported, the following tax shall be. Shall be is like must, all right? And they're trying to change that now to different, but whenever you see shall be, it's kind of like there's no option, but you have to do it, right? And if you're not doing it, you're in trouble. So this is the way Congress has written it, and so pretty much once those small cigarettes hit the border, tax liability is imposed upon declaration. So when you fill out that CBP form 7501, excise taxes in addition to duties must be paid. All right. So fortunately, we haven't seen that many questions dealing with excise taxes. So I think this brief introduction into the topic will suffice. This is one of the questions that came up recently. So I felt like it is worth time to mention because usually they tend to relapse. A few years go by, again they appear. So keep this in mind. Note that when you see the word excise tax, most likely it is the mandatory tax, and if you see that word, your fingers should automatically go to that CAT-ER outline or CAT-ER printout that you must bring to the customs exam appendix